Before a judge ever speaks, the crowd already has no oath, no evidence, no burden of proof, and yet, its verdict lands first. It's time we examine the court that isn't in the courthouse.
The cost of public opinion in a court. There are two courts involved in every high-profile dispute. One operates inside a courtroom. It is governed by procedure, evidence, and burden. It moves deliberately. It requires proof. It renders judgment only after rules have been followed. The other operates outside that building. It has no oath, no evidentiary rules, and no standard of proof. It deliberates in headlines, comment sections, social media threads, and broadcast panels. It renders judgment quickly. It rarely revisits its conclusions. That second forum, the court of public opinion, has always existed. What has changed is its speed, reach, and permanence. In the modern media environment, public sentiment can form within hours of an allegation. It can influence reputations before pleadings are filed. It can reshape legal strategies before discovery begins. Today's subject is not whether public scrutiny is good or bad. Transparency is essential to a functioning legal system. Courts are public institutions for a reason. The question is more precise. What is the cost when public narrative begins to compete with legal standards? What happens when popular truth starts to influence litigation itself? This issue affects criminal prosecutions, civil lawsuits, family disputes, corporate litigation, regulatory enforcement actions. Every context in which litigants enter the legal system expecting resolution through law rather than popularity. The structural difference between legal truth and public narrative. The legal system is built on defined burdens. In criminal cases, the prosecution must prove guilt beyond a reasonable doubt. The defendant is presumed innocent. Evidence must be admissible. Procedures must be followed. In civil cases, plaintiffs bear the burden of proving their claims by a preponderance of the evidence or, in some cases, by clear and convincing evidence. Defendants have structured opportunities to challenge those claims. Judges apply precedent. Juries receive instructions. Legal truth is not determined by volume of accusation. It is determined by sufficiency of proof under defined standards. Public narrative operates differently. It does not wait for admissibility rulings. It does not distinguish between allegation and evidence. It is influenced by emotional resonance, visual impact, and rhetorical framing. It rewards clarity and speed, not nuance and patience. This distinction matters because legal disputes are often complex. Contracts turn on interpretation. Negligence cases hinge on standards of care. Regulatory enforcement may involve technical compliance frameworks. Criminal prosecutions may depend on circumstantial evidence assembled incrementally. Public discourse prefers simplicity, a wrongdoer and a victim, a hero and a villain. Litigation often resists that framing. When these two systems intersect, tension is inevitable. When narrative shapes litigation strategy. In high-visibility disputes, attorneys frequently manage two parallel arenas, the courtroom and the narrative environment. Consider civil litigation involving a corporation accused of misconduct. Even before liability is determined, the company may face reputational harm, investor pressure, customer backlash, or employee instability. Settlement decisions may be influenced not solely by legal exposure, but by brand preservation. The financial calculus expands beyond damages to include reputational risk. On the other side, a plaintiff bringing a claim may face public skepticism. Allegations of opportunism or exaggeration can circulate long before discovery clarifies the factual record. In employment disputes, professional reputations can be damaged on both sides before any adjudication. In criminal matters, the dynamics are even more pronounced. Prosecutors may experience pressure to file charges quickly in response to public outrage. Defense attorneys may advise clients to remain silent publicly, even when silence is interpreted as guilt. Plea negotiations may occur under intense scrutiny. In all of these contexts, legal strategy is no longer shaped solely by evidence and law. It is shaped by perception. There is nothing inherently improper about acknowledging public context. Lawyers have ethical duties to their clients, including advising them about reputational consequences. The concern arises when narrative pressure begins to override legal evaluation. When optics dictate decisions more forcefully than evidence, the system shifts. That shift is subtle. It does not announce itself, but it changes incentives. The expectation problem, media conditioning and litigation reality. Entertainment media and continuous news coverage have conditioned public expectations about how disputes unfold. In criminal law, this phenomenon is often described as the CSI effect. Jurors exposed to forensic-heavy television programming may expect advanced scientific evidence in every case. The absence of DNA, fingerprints, or digital tracing can be interpreted as investigative deficiency rather than as a reflection of reality. In civil litigation, a parallel dynamic exists. Popular culture trains audiences to expect smoking gun emails, dramatic cross-examinations, and decisive confessions. Real litigation rarely unfolds that way. It is document-intensive, incremental, and often technical. For example, a complex contract dispute may revolve around industry standards, regulatory interpretation, or ambiguous language negotiated years earlier. A professional malpractice case may hinge on whether conduct fell below a standard of care defined by expert testimony. These are nuanced determinations. Public commentary, however, tends to reduce disputes to simplified moral conclusions. This expectation gap can influence jurors. Jurors are instructed to apply the law as given by the court and to consider only the evidence admitted. But they do not enter the jury box as blank slates. They bring cultural expectations shaped by media exposure. When those expectations clash with the slower, more technical reality of litigation, dissatisfaction can arise. Parties may feel pressure to present their case in a more narrative-driven manner. Lawyers may adjust presentation styles to meet anticipated juror expectations, influenced by broader media culture. Again, the issue is not that jurors are incapable of fairness. It is that the environment in which they form expectations has changed. The human cost to litigants. Litigation is inherently stressful. It disrupts routines, finances, and emotional stability. When disputes become public, those pressures intensify. A litigant, whether plaintiff or defendant, corporation or individual, may experience reputational harm independent of legal outcome. Employment relationships can be affected. Business partnerships may dissolve. Professional licenses may be scrutinized. Social relationships may strain. In civil disputes, even filing a lawsuit can invite public commentary. A party asserting a claim may be labeled litigious or opportunistic. A party defending a claim may be assumed culpable simply because litigation exists. In criminal proceedings, the presumption of innocence is a constitutional safeguard. But social reaction does not always mirror that principle. Accusations can trigger immediate condemnation. Importantly, vindication does not automatically repair reputational harm. An acquittal, dismissal, or defense verdict closes the legal matter. It does not erase digital archives. Search engines preserve allegations long after exoneration. Corrections, when they occur, rarely circulate as widely as initial accusations. The emotional toll can be profound. Anxiety, financial strain, public scrutiny, and uncertainty compound the inherent stress of litigation. For some litigants, the reputational consequences exceed the legal penalties or damages at issue. Due process protects procedural fairness. It does not guarantee reputational restoration. Appellate courts and media saturation. Appellate courts are often tasked with reviewing whether pretrial publicity or pervasive media coverage compromised fairness. They consider whether venue changes were appropriate, whether jury selection procedures sufficiently screened for bias, and whether judicial instructions effectively limited external influence. The threshold for reversal is high. Courts generally presume that jurors follow instructions, and that exposure to media coverage alone does not establish prejudice. However, history includes instances where intense, prejudicial publicity undermined proceedings. In such cases, appellate courts have intervened. The balance is delicate. The First Amendment protects freedom of the press. The Sixth Amendment guarantees the right to a fair trial in criminal cases. Civil litigants are also entitled to impartial adjudication. Neither principle is absolute. Courts must navigate the tension between openness and fairness. In an era of instantaneous digital dissemination, that navigation becomes more complex. Media exposure is no longer limited to local newspapers or evening broadcasts. It is continuous and global. Appellate review is retrospective. By the time a case reaches appeal, the public narrative may have solidified. Reversal can correct legal error. It cannot rewind public perception. Institutional effects. When pressure outpaces precedent, public sentiment does not influence only individual cases. It can affect institutional behavior. Prosecutors may alter charging practices in response to public demand. Legislatures may enact reforms quickly following high-profile events. Regulatory agencies may adjust enforcement priorities. Civil settlement culture can shift when reputational risk becomes a primary concern. Sometimes these shifts reflect legitimate social evolution. Law does not exist in isolation from society, but rapid reaction carries risk. When momentum replaces deliberation, unintended consequences can follow. History includes examples of wrongful convictions and unjust civil penalties that unfolded amid intense public pressure. In such climates, restraint can appear unpopular. Patience can appear insensitive. Yet due process depends on both. Precedent exists to provide consistency and predictability. When short-term sentiment overrides established legal principles, stability erodes. The rule of law depends not only on outcomes, but on process. If litigants begin to perceive that results are shaped more by popularity than by proof, confidence in the system declines. Transparency versus substitution. It is essential to distinguish between scrutiny and substitution. Public oversight of courts is healthy. Reporting on legal proceedings informs citizens. Critique of institutions can drive reform. Transparency deters abuse. The danger arises when public opinion substitutes for legal standards, when allegations are treated as conclusions, when trending narratives shape adjudication, when moral condemnation replaces evidentiary analysis. The court of public opinion will always exist. It is a feature of democratic society, but it is not bound by procedural safeguards. It does not administer oaths. It does not exclude inadmissible evidence. It does not apply burdens of proof. Litigants enter the courtroom with the expectation that law, not popularity, will govern resolution. Preserving that distinction is essential. Conclusion. Guarding the boundary. Every high-profile dispute now unfolds in two arenas. The legal system must continue to operate within its defined structure, even as external commentary accelerates. The cost of failing to maintain that boundary is significant. Strategic decisions distorted by optics. Reputations damaged beyond repair. Juror expectations misaligned with legal standards. Institutional reactions driven by momentum rather than precedent. Confidence in adjudication weakened. Justice requires patience. It requires restraint. It requires adherence to burdens of proof, even when public impatience is loud. The existence of public opinion is inevitable. Its influence is powerful. But the legitimacy of courts depends on their refusal to be governed by it. The unseen jury may always deliberate, but the sworn jury and the judge must decide. And that distinction must remain clear if law is to remain law.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.